Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will bring
relevant.
the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
Alex stole it as well.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court. The fireworks are not done.
Or getting commentary on the case. Not him, he's Anglican boy, he's verbal clubbing.
That's literally not true.
I didn't ask you to interrupt me.
Is that correct?
All right, welcome. Welcome back to the Court of Public Opinion. I am the Recovery Addict. We are about to jump to Utah. Sorry, right in the middle of the intro, they kicked on the live feed for the pool media. So we do have our feed set up here. We're waiting for them to focus and do all the things that they do, which is slowly have to focus. There we go. State of Utah. There's our seal. All right, we're going to be back in Utah here in just a minute. And first of all, just have to welcome everybody here. Thank you very much. Appreciate you all. So I can click all the right buttons. First and foremost, we're going to welcome Rianne K. Rianne, congratulations, you're first in chat today. That honor brings you the pleasure of being the internet owner for the rest of the afternoon. So yes, everything IP-related worldwide is your responsibility. And good riddance.
Hello.
Off my shoulders and onto yours. It's wonderful. Whew, we jumped all the way from New Jersey to Utah. That was a quick trip, shaky grounds. I'm glad we all made it safely. Check around for your portal buddy. If they're not there, send them a quick text. Let's get them all here, and we can get started on time. Top Mark Media is live as well. If we can get somebody over there to just give it a thumbs up. I'm showing the stream is looking good, but just let me know if the audio has any problems on that end. I can do a little bit of tweaking on that as well, but I have to do it separate. I'm managing the audio for 2 different streams completely separately, like 2 different devices. So hopefully it won't take too much work. Utah's pretty good with their audio and their court systems. What is with Utah? I love it. Open courts are wonderful. We always say, Florida man did what? Florida is also an open court system, and we're excited for that. Okay, we're getting only one channel of audio. I can fix that on our side. There we go. Camera's going all over the place. This portion of the trial is not sponsored by ViewSonic, which makes great monitors that the judge has. But just want to see audio levels on the court feed.
Yes. And your acknowledgement.
Wow. Bummer. The clean feed we're supposed to have over on Top Mark Media has the pool feed overlay on it. But it is what it is. Sorry about that. I've got a clean feed over here, ironically, and they don't have one, so bummer. What does that mean? A clean feed is a video from court with no overlays, no brands from a television channel or news outlet. It wouldn't say Court TV, Law and Crime, Channel 2, NBC 10, Nate Eaton, whatever, East Idaho Press, East Idaho News, whatever feed is you're watching. A clean feed has none of that. As pool media, we're supposed to have a clean feed, and we're not getting one. Although I have one, which is a little ironic. It's all right. We'll be okay. Let's see. Anyway, I'm loving that we're getting a lot of courts from Utah. I hate that there's a lot of crime. Obviously, the best thing that would happen is for crime to stop being a thing. But seeing that has not happened, the next best thing is we get to watch the judicial process. And people are connecting right now via the WebEx. Hello.
Please be seated.
Oh, here we go. We'll turn this down.
Court is now in session. Calling case 251-501-576, State of Utah versus Tyler James Robinson. Counsel, could you please enter your appearances?
Good morning, Judge. Chad Grunander, Ryan McBride, Chris Ballard, Lauren Hunt, and Jeff Gray for the state.
Good morning.
Good morning, Your Honor. Kathy Nestor, Richard Novak, Stacy Visser here for Mr. Robinson, who's seated at the table.
Good morning.
Good morning, Your Honor. Jeff Hunt and Mike Judd on behalf of the news media.
Good morning. And the court also recognizes Mr. Robinson. Good morning to you. All right, before we address the motions before the court will take up a couple of preliminary matters. First, with respect to courtroom protocol, to maintain security and decorum, any individual who exits the courtroom during the proceedings will not be permitted to re-enter until recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. I will note that for today's hearing, we're going to turn off the microphones at the jury box and at counsel table, and so I ask in order to avoid picking up inadvertent conversations or communications. And as you speak, if you wouldn't mind just coming to the lectrum, and that will be the microphone that will be live for this hearing. Next, turning to the camera operator and still photographer. So would the two individuals responsible for video and still photography please come forward and state their names for the record.
I've never seen this before.
Your Honor, Trent Nelson with the Salt Lake Tribune is still photographer.
Good morning.
Your Honor, Jeremy Dubas, KUTV 2 News videographer.
Good morning. All right. The court's purpose is to ensure the clarity regarding the expectations governing today's proceedings. And have you reviewed the court's standing decorum order dated February 24th, 2026?
Yes, Your Honor.
Yes,
All right.
Your Honor.
And do you understand the requirements set forth in the order as they apply to your activities today?
Yes, Your Honor.
All right. Do you require any additional time to review the order or to adjust equipment to ensure compliance?
No.
And do you anticipate any difficulty complying with the order or the court's instruction?
No, Your Honor.
All right. Well, Mr. Nelson, Mr. Dubas, I appreciate your cooperation today. Thank you.
Judge is going to do this for every hearing.
Turning next to discovery for the state, could you provide a brief status update regarding discovery? Mr. McBride.
Well, we had provided I'm sorry.
Go ahead.
As of May 12th, we had provided 100% of the material in our possession. We received additional discovery from the State Bureau of Investigation over the last week, and that material will be transferred to the defense very soon, probably this afternoon.
All right. Thank you, Mr. McBride. Turning to defense, do you request the benefit of the record?
Thank you, Your Honor. Since our last status update on May the 4th, we have received a total of 2,462 more files. Over 2,300 of those were residential surveillance camera videos. Many of those we did have previously. The remaining files were ATF and FBI without the DNA data, reports and files, and then some 1102 statements, some jail records, some other law enforcement reports. I appreciate that the state has given us 100% of what they have. We really don't have a feel for how much they still have not gotten. I don't know if they know. It seems like it's just constantly coming in, but we do appreciate how fast they're turning it over. But when you say we have 100%, I think what they're saying is they have 100% of what they've received has been sent to us, but there's still maybe quite a bit out there that we just don't know how much it is.
All right. Thank you, Ms.
Your
Nestor. All right, well, let's turn to defense's motion for an order to show cause for alleged contempt of court and for an order compelling discovery related to the alleged contempt. And just for management purposes, each side will have 30 minutes to present argument. If defense intends to reserve time for rebuttal, counsel should plan accordingly. Afterward, we'll take a 10-minute recess. And because this is defendant's motion, defense will proceed first. And again, as a reminder, this argument is in regards to whether the court grants an evidentiary hearing to hear additional evidence. And that's the decision that's before the court. With that, turning to Mr. Novak.
Thank you, Your Honor, and good morning.
Good morning.
I think as the court stated, there really are two issues before the court today. One is whether under Utah Code Section 78B-6-301 et sec, this court has an obligation to issue an order to show cause and set an evidentiary hearing. And the second question is whether, in preparation for that, the court makes a finding under Rule 16 of good cause to compel the state to comply with our informal discovery request. And what I would like to say is that it seems beyond debate, based on the evidence before this court already, that the court does have an obligation to set an OSC evidentiary hearing. It's important also to note that the statute 78-6-309 actually says that the court investigates the alleged contempt and may call witnesses. So I'm actually, if I may, going to address the two issues in reverse order, which is the discovery issue and then the hearing issue. The communications, the events, the conversations, the state of mind of the various members of the prosecution team with respect to the decision for Mr. Ballard to go on what I will call a media tour is central to not only the core question of whether there's been a violation of the court's order, but frankly, the egregiousness of that violation. While we pointed out in our papers, and the state did not take issue with this in theirs, that because the court's orders, the court's pretrial orders, are injunctions, we don't actually have to prove there's been an intent to violate the order. The fact that what I'm going to call an alleged contemner knows of the order and has failed to comply with it, those two elements are all that is necessary. But the question of the seriousness of the violation, the sanctions that should be imposed in light of the violation, do get at intent. So intent is not irrelevant, but it's not an element of what I might call the alleged offense of contempt of this court's orders and violation of Rule 3.6 and 3.8. So we think that this court can't really fulfill its statutory duty to investigate without the parties, well, without the court and Mr. Robinson knowing what communications the Utah County Attorney's Office had with various media outlets, what the nature of those conversations were, what the nature of the internal conversations were concerning whether Mr. Ballard should go on Fox and Friends and have a nationally and internationally televised interview, whether the Utah County Attorney's Office should issue emails to media entities, and the Supreme Court's decision, which has been cited to this court in the briefings in the matter of Levitt, clearly show this court that the alleged contemner's awareness of problems with their conduct is central to the inquiry. So one of the first things that the Supreme Court said in its opinion was that after Mr. Levitt had his press conference and he went back to his office, people in his office said, wow, that's a problem. And so that internal communication is central to this court's assessment of what we would call the seriousness of the violation.
Well, Mr. Novak, let me stop you right there. Is the violation what happened allegedly? Because I haven't watched the interview or what's been purported. Are you saying the violation for the potential sanction is what happened on the news or what happened behind closed doors?
The violation is what happened. The violation is extrajudicial statements that have a substantial risk of impacting the proceedings. Okay, and the two specific violations are Mr. Ballard's statements on behalf of the Utah County Attorney's Office. So the question really is, and I'm not suggesting that this is the case, but the question is, did Mr. Ballard go off on his own and do this all by himself, or was there a management decision to go do this? Okay, but the conduct that is a violation of this court's orders is to make extrajudicial statements about forensic evidence, not only what the forensic evidence is and the testimony will be, but if the court looks closely at especially Ms. Visser's declaration filed in support of the motion, Mr. Ballard commented on what future versions of ATF and FBI reports will say after future testing is done, as if he somehow had a crystal ball as to what the evidence ultimately will be. And the second violation is statements that clearly are expressions of opinion as to Mr. Robinson's guilt. And these are two of the examples highlighted in the comments to Rule 3.6. I mean, this is textbook, don't go out and say these things extrajudicially. And if the court looks at the exhibits to our motion, what the court sees is the Utah County Attorney's Office was very cognizant of the fact that Rule 3.6, Rule 3.8, and this court's orders prohibit those kinds of statements because they sent letters to what I will refer to as their law enforcement partners, basically saying, don't go out and make extrajudicial statements. So I'm going to get back to the court's question. The court's question is, where is the violation? The violation is the extrajudicial statements. What I'm saying about the need for this court and for Mr. Robinson in order to meaningfully participate in the OSC hearing to understand how it is that Mr. Ballard came to be going on this media tour, because that gets to the seriousness of the misconduct and the types of sanctions that are appropriate. So I'm not saying that a conversation between Mr. Ballard and, let's just say hypothetically, Mr. Gray, that's the question, is where did these conversations start and where did they end that led Mr. Ballard to send emails to media entities and agree to sit in a studio or at least online and talk to Fox News? That's not, the conversations are not the violation. The conversations guide this court to the state of mind with respect to the violations and the sanctions that are appropriate for violation of the order. The other question, which is related, is what is the harm to Mr. Robinson, which is something that this court is going to have to grapple with now. And as the bomb litigation demonstrates, and we attach what we think are the relevant orders from the bomb litigation, the remedies that are necessary to attempt to return Mr. Robinson to the place he should be in terms of the presumption of innocence, in terms of having a jury that hasn't been impacted by these violations. So the discovery request is narrowly tailored in time. It's from March 26th until whenever the production that we requested was made, March 26th of this year. We were not asking the state for every single communication they've ever had with a media outlet since September. We were asking for communication since March 26th because it was clear that the moment we filed our motion to continue the preliminary hearing, the state decided that the way they would shape the media conversation about Mr. Robinson's case was to issue emails to the media and have live interviews.
They did a press release and said this is a death
Counsel,
penalty case.
you mentioned 78B-6-309, and it states the court shall proceed to investigate the charge and hear any answer which the person arrested may make. So would you agree it's the court's duty to investigate and decide what is necessary for the court to make that decision?
Mr. Robinson's there in the white shirt.
The court is entrusted with deciding whether or not there's good cause to require discovery. And I'm saying that in order for the court to conduct the investigation, which is required by the Utah Code, the court needs the materials that we were requesting. And good cause means materiality. So clearly, the communications between the Utah County Attorney's Office and the media and the internal communications, not about case strategy, not about witnesses, not about evidence, but about communications with the media, which led to what we think clearly is a violation of this court, 2 violations of this court's orders, is germane and necessary to the court's investigation. However, that doesn't mean that this court conducts an in-camera proceeding that Mr. Robinson is excluded from. We are the moving party. We have very serious constitutional rights, which we need to make sure that this court
upholds,
understands the nuances of in terms of the impact of the conduct and the seriousness of the conduct. So this is not a situation where the court, in my view, should receive the materials we requested in camera, not share them with Mr. Robinson, and not permit Mr. Robinson to participate in the OSC. I don't know if that was what the court was suggesting. What I'm suggesting is that the court should compel the state to give us the materials which we requested. If there is any question as to whether some of it may be privileged, the court can review it in camera, which is what we said in our papers. But that doesn't mean that the court conducts its own ex parte in-camera proceeding without us participating.
We still want the information.
Sure. No, I'm not suggesting that. I'm
Then
simply saying.
Then I read something into the court's question that was unnecessary.
Right. What I'm saying is would you agree as part of this investigation in a hearing that the court determines what is necessary for the court to make that decision in regards to your request for discovery?
Yes, I think the court has to exercise discretion, but it's our position that the appropriate exercise of discretion is to compel the disclosure, for the court to review those materials, for Mr. Robinson to review those materials. If the court is concerned that internal deliberations produced in discovery need to be subject to some sort of protective order before there's an evidentiary hearing, that's fine. We've always been fine with protective orders. I think that we've been the party in this case has always said less premature public disclosure of sensitive materials is best. Okay, and that, if I may, actually leads me to this.
They're trying to shut everything
what I'm going to
down.
call a diversion about this ATF report. Okay, so our motion to continue did not mischaracterize the ATF report. What the state wanted to do is expand upon the inconclusive nature of the ATF report. And instead of doing that in this courtroom, they went on a media tour to do it because the media misinterpreted what we said in our motion to continue. Our motion to continue is accurate with respect to the ATF report. And I would also point out that it was Mr. Ballard, and this is an email from Mr. Ballard to us attached to Ms. Visser's declaration, which says that the state thinks that that ATF report should stay under seal because to publicly file it would be a violation of 3.6. It would be an end run, to quote Mr. Ballard, around Rule 3.6, because it would be filing in the public record a forensic report. Okay? So, but at some point in time, for some reason, the state decided that report should become public and everything should become public. And the court granted that motion. And so that ATF report became a public document. And so in a court filing, we accurately characterized what's in that ATF report in support of our motion to continue. The court is well aware that there has been a dispute about the FBI's desire to do destructive testing without documenting that testing or allowing one of our ballistic experts to observe the testing. And so that's sort of like sitting there. But that's why that ATF report was initially lodged with the court in camera until the state decided, or I should say privately, to use the appropriate Utah term, until the state decided that it wanted it to become a public record. Okay? So the other thing that I want to say, and I'm going to save a few minutes, is that the state tries to take refuge in the notion that because we've made public statements, albeit in court filings, about something that the state thinks has been mischaracterized, that they get to go out and talk to the media to correct things. And that is not what Rule 3.6 permits, and that is not what the Supreme Court in the Levitt situation and in the Baum litigation sanctions. If Mr. Ballard and his colleagues thought that we mischaracterized the ATF report, which we did not, but if that's what they really believed in good faith, they could have done at least three things. One, they could have filed something with this court, a judicial communication which said, we think that Mr. Novak and his colleagues have mischaracterized this ATF report, and our view of the correct characterization of the ATF report is as follows. Number two, they could have reached out to us and said, we think that you have either inadvertently or intentionally misconstrued or mischaracterized this ATF report, and we would like the parties to file something, or we would like you to consider amending your filing. They could have done that. Neither of those things happened. Instead, what they did was they drafted an email and they sent it to media entities like TMZ, and they scheduled an interview for Mr. Ballard with Fox and Friends, where he characterized it extrajudicially.
TMZ?
And that's exactly what 3.6 prohibits.
Say it
the
ain't
fact
so.
that they didn't agree with the way we characterized evidence to this court is not an excuse for violating 3.6 and not an excuse for violating this court's orders. And this court will remember, I'm going to conclude now, that when the state challenged this court's pretrial and trial order and said that it was a prior restraint and that it was vague, I stood here and I defended the court's order because it wasn't a prior restraint on anybody other than counsel and their investigators. It's not a prior restraint on witnesses. It's a prior restraint on counsel. So there is no doubt that they understood that they can't be making extrajudicial statements about Mr. Robinson's guilt or innocence or about the forensic evidence. Those are two comments that are right there in Rule 3.6. Mr. Robinson has a right to a presumption of innocence until the matter is submitted to the jury. This court's done jury selection, I'm sure, in many different ways. And when the jury is in the box being selected, he has a presumption of innocence. Every day he has a presumption of innocence until the matter is submitted to the jury for deliberations. And that is something that Mr. Ballard knows, and he and his colleagues violated that right. And this court, in my view, needs to get to the bottom of why did this happen, who was involved, what was the state of mind, why didn't they do what the law requires, which is file something if they thought a correction of the record is necessary. The ATF report is in the public docket. It's there. It doesn't matter what Fox, CNN, MSNBC, TMZ, it doesn't matter what they think of the report or what they think of our pleading. The only person who judges our pleading is Your Honor, not the media. I've saved 3 minutes.
All right, just a quick question for you.
Of course.
Assuming the court grants the request for an evidentiary hearing, how much time do you anticipate needing to present what you would like to present, assuming, and if there's a difference, assuming you do get discovery that you're requesting, or if you don't get discovery, I just want to take that in consideration as well.
Thank you, Your Honor. I appreciate the question. And unfortunately, the discovery will tell us how many members of the Utah County Attorney's Office were involved in this decision.
And who needs to be
If it was Mr. Ballard all by himself, then there may only be one witness. I think the media evidence speaks for itself. We've lodged some of it as exhibits and some of it through hyperlinks, all in Ms. Visser's declaration and the attachments to it. If the discovery shows that there was a team meeting and there were a bunch of emails about it, then it may be that there has to be, that from our view, multiple people need to be examined under oath. So I'm not trying to dodge the court's question. I think that it's definitely no greater than a single day. I mean, I don't think this is a multi-day hearing. But I think the question is, how many people were involved in the decision for Mr. Ballard to go on national television and send emails to the media? And I can't answer that question, and so I can only give the court this general idea that I think it's a serious hearing that should take no more than one day.
And if the court doesn't grant the request for discovery and it's that sole witness, and I'm not holding you to that, obviously, how much time would you anticipate that would take?
So then, if I may, the examination, and I can only start with Mr. Ballard because he's the one who made all the public statements. The first questions would be, who did you discuss this with and when? And then we're going to get into hearsay, and then we may or may not have additional witnesses. I mean, it's like kind of like an onion. So I actually think that we should see.
They want witnesses, a lot of them.
What's in the soup before we figure out how long it takes to make it. I apologize for the food analogy this early in the day, but I think the court understands what I'm saying.
Thank you, Mr. Novak.
All right, thank you, Your Honor.
Turning to the state.
This is a fishing expedition. Defense has caught the state doing something that looks wrong. They're trying to get every scrap they can of evidence that they can dig through that might expose other things or other people, which will further some of their arguments to eliminate media, to eliminate evidence, and to eliminate personnel from this case. They've sought all three of those. Maybe even also use this as an argument for a change of venue.
May it please the court. I think the first question is, has the defense shown adequate basis to merit further proceedings here? Whether those further proceedings are discovery or an evidentiary hearing, the reality is that defendants has already mustered the prejudicial statements, right? That's what we're talking about here, is the statements that have been made in the media. The defense has investigated that. They've reported the most prejudicial statements that they can find, and that's what the real question is do those statements violate the court's order and Rule 3.6? It doesn't really matter what other discovery shows. Maybe it does to a sanctions hearing, but certainly not to whether or not there's a contempt violation here that Rule 3.6 has been violated. So the question is, has the defense mustered that evidence and that information necessary to merit additional proceedings? And I think the best way to do that is to look at the statements and determine on their face whether there is a good faith basis, whether there is adequate evidence the defense has mustered to require additional proceedings. And so I think we start with the law. When there is pervasive media that misrepresents the evidence, that misrepresents the facts, and that creates a material risk of prejudicing the rights of a party, an attorney has the ability under Rule 3.6 to correct those statements. And in fact, they have the duty, under a duty of zealous advocacy to their client, to respond. In this case, there was a tidal wave of media garnering more than 10 million views in a matter of hours that mischaracterized the evidence, that misrepresented the evidence, that misled the potential jury pool as to what the evidence was. That media, of course, reached Utah County. It was widespread, and it created an undue risk of prejudicing or tainting the jury pool. As a result, the Utah County Attorney's Office had the ability under Rule 3.6 and the duty as a zealous advocate to respond and to correct those mischaracterizing statements, those inaccurate and misleading materials. Now, when we think about prosecutors, often we refer to prosecutors as the state, and that's because prosecutors have one client, and that's the state of Utah. But it's important to remember that prosecutors are attorneys who have a duty of zealous advocacy and an ethical duty to their client just as stringent and as rigorous as any other attorney, an attorney for a civil client, an attorney for a criminal defendant. And their duty is to ensure that their client's legal rights are upheld and defended. And when an attorney sees that their client's legal rights are attacked, that attorney's whole job, the reason they have a job, the reason they are paid by their client, is to protect and uphold those rights. Usually, this is performed in the courtroom, but occasionally it must also be performed in the media. That's what Rule 3.6c is all about. An attorney cannot stand idly by while his client's legal rights are undermined and trampled upon by mischaracterizations of the evidence, by misrepresentations of the evidence, by misleading media reports. Instead, the attorney has the duty to protect his client's legal rights by correcting that misleading statement. Now, I've mentioned the misleading reports by the media, but I want to be clear, I don't place the blame on this for the media. These are reports the media has repeated from defense counsel's misleading statements, and I disagree wholeheartedly with defense counsel's statement that their statements in their pleading was not misleading, because it absolutely was. In defendant's motion to continue the preliminary hearing, the defendant stated this: the ATF was unable to identify the bullet recovered at autopsy to the rifle allegedly tied to Mr. Robinson. Okay, so let that sink in. That's the statement they included. The ATF was unable to identify the bullet recovered at autopsy to the rifle tied to Mr. Robinson. That statement is not inaccurate. That statement is accurate. They were unable to identify that bullet to that rifle, but it's incomplete. It's not the whole truth, and as a result, it's misleading. It actually has two material omissions. Material omission number one is that the ATF was unable to identify or exclude that bullet as having come from that rifle. Okay? And then defense counsel compounds the misleading nature of that statement by following it up with this: the defense may very well decide to offer the testimony of the ATF firearm analyst as exculpatory evidence. We all know what exculpatory means. That means evidence that proves he didn't do it, right? That's affirmative evidence that shows he didn't do it, right? That's the misleading nature of this statement, because it is not exculpatory evidence. If that omission, that material omission was included here, that the ATF was unable to identify or exclude the bullet, everyone would know that this is not exculpatory evidence. And that leads me to the second material omission, which is the analyst reported that the bullet was a .30 caliber class bullet jacket fragment. Okay, .30 caliber class. What does that tell you? Well, that excludes a whole bunch of weapons from possibly being the weapon in this case. And on the short list of weapons that are included is a .30-06. Right? The weapon that was found at the scene. The reason that omission is material is because it shows that this evidence is not in fact exculpatory. This report and the testimony from this analyst will be inculpatory, because on the short list, from that bullet came from a weapon that is on the short list, which includes the weapon that was found at the scene. That's inculpatory evidence. By no stretch of the imagination is the testimony of this witness exculpatory. Your Honor, that's a misleading statement. And it's not surprising that the media covered it and covered it the way they did, because any reasonable reading of those statements with those two material omissions leads to the conclusion which the media drew, which is that the bullet does not match the gun. This is exculpatory evidence. That's what the defense claims. Under no stretch of the imagination could this witness be exculpatory. The result of the analysis substantially narrowed the class of weapons that could have fired the fatal bullet, and the defendant's rifle was on the short list. That's the truth. Now, the media ran the story, and it gathered extraordinary attention. I've noticed that the monitors are turned off. Are we still on the record? Okay, thank you. The Daily Mail ran a story garnering 22 million views on X in a single day. And the headline was, "The bullet used to kill Charlie Kirk did not match the rifle allegedly used by Tyler Robinson." Okay? The bullet did not match. Major networks throughout the country and even throughout the world picked up this story and echoed it, echoed this statement that came from defense counsel's pleading. I don't lay that blame on the media. That's accurate reporting of what the pleadings stated and a reasonable inference. But they echoed that misrepresentation, that misleading news. Major news networks reported that this ATF report exonerated Robinson, that the prosecution's case had fallen apart. There were quippy headlines like, "If the bullet doesn't fit, you must acquit." And that, of course, reached Utah County, where our jury pool resides. The Deseret News, a Utah agency, had a story entitled, "How One Headline Shaped the Narrative in the Tyler Robinson Case." I mention these to tell you I'm not over-exaggerating, I'm not overstating the breadth of the media coverage here and the risk of prejudicing a client's legal rights and the right to a fair trial. So what does an attorney do? You see this happen to your client. Your client's case the evidence is being mischaracterized, misrepresented. We all know it because we know what that report actually says. We have the report in our hands. It's actually public information. But now the media is relaying the same information, mischaracterized by defense counsel, and prejudicing your client's right. What do you do? Well, you do what Mr. Ballard did. He looked at the rule. Looked at Rule 3.6, subsection C, and it states, "A lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial, undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client." That's the law. Let's go through it and apply it. A lawyer may make a statement, which Mr. Ballard did, that a reasonable lawyer would believe is required to protect a client from the substantial, undue prejudicial effect of recent publicity. Is there substantial publicity here? Yes. 22 million views in a day, we've covered that. Undue prejudicial effect, is it undue prejudicial effect? Yes, it is, because it's a mischaracterization of the evidence. The report does not say that the bullet did not come from that gun, which is what the media was stating. Right? That's undue prejudice. It's unfair, and it's not accurate. And that is recent publicity. Not initiated by the lawyer or the lawyer's client. Mr. Ballard didn't start this, right? The state didn't start this. This began because of a pleading the defense counsel filed in the court, right? And the rules don't require that defense counsel, in order for an attorney to respond, it doesn't require that the opposing party make the prejudicial statement to the media. All that's required is that the media is making some prejudicial statement that's reaching your jury pool and prejudicing your client's rights. So Rule 3.6 is directly on point. It allows an attorney to make statements to correct this misleading material, to correct the facts. And I would say it's not only permitted, but it's a duty to respond. As an attorney, you have a duty to watch out for your client's interests. Zealous advocacy is enshrined throughout the rules of professional practice. Comment 1 to Rule 1.3 states, a lawyer must act with commitment and dedication to the interests of the client and with zeal in advocacy on the client's behalf. When your client is being unfairly attacked, when their legal rights are being undermined, you as an attorney don't have the luxury of sitting there and watching it happen. You have a duty to stand up and represent your client. Again, usually that happens in the courtroom, but occasionally, like Rule 3.6 says, you have to do it in the media too to protect your client's interests. And Mr. Ballard performed that duty by making a statement that accurately characterized the evidence. He had the report in front of him, and he told the media in these interviews exactly what that report said, which is how defense counsel actually characterized it today, unlike their motion, which is that this was an inconclusive report. He characterized the evidence as the test characterized the evidence, that it was inconclusive. There was not sufficient material to compare with test-fired rounds to either draw the conclusion that it was included or excluded as having been fired from that rifle, that the bullet was either included or excluded. The evidence didn't have adequate characteristics to make that comparison. That was an accurate statement in the evidence. But to show that Mr. Ballard was circumspect in his response and was abiding by his ethical rules, he did not go a step further. He could have, but he did not go a step further to explain the inculpatory nature of that report. Right? What he did is he corrected the misrepresentation the defense counsel had in their pleading. He said, nope, that's not what the report means. It does not mean the bullet did not come from the gun. It means that this is an inconclusive finding. He could have gone a step further and included the other fact defense counsel omitted, which is, but the report shows this bullet is a .30 caliber class bullet, which is consistent with having been fired from the rifle found on the scene. He didn't say that. He could have, but he didn't. Why not? Well, because he's being circumspect. He's abiding by his ethical duty. He's not putting forward additional evidence that proves guilt. He's just correcting the misinformation that was out there.
Well, let me stop you right there. You used the word zealously, but isn't that referring to defense attorneys to advocate for their clients, and under the rules, Utah prosecutors are to act as ministers of justice? Is there a different standard?
I would say there's a greater standard of zealousy for prosecutors than any other attorney, to be honest, because their duty is to the truth, right? Not just to represent the interest of a client, whether that's a criminal defendant or a business or a civil client, but they have a zealous duty to their client and to the truth even, right? And that's why if Mr. Ballard had come out and said, no, the report says it came from that gun, and had some kind of misrepresentation, and he said, no, I'm being a zealous advocate right now because that's what I think is going to be shown in the long run, that would be a problem. But this was zealous advocacy and a commitment to the truth here. He was representing the true nature of that report, right? The duty of zealous advocacy does apply to attorneys for the state, but they are ministers of justice, and I think it means that their duty of zeal possibly even exceeds that of other attorneys. Certainly, they're not accepted from being zealous advocates. So he did. He made that statement, a statement that accurately characterized the evidence, corrected the misrepresentation, the misunderstanding, and the mischaracterization of the evidence. He stated the test was conclusive, and he did not go a step farther or further to then pile on and say this is what the evidence actually shows and talk about the inculpatory nature. Maybe you're right. As a zealous advocate, maybe he could have gone a step further, but he didn't. And I think that was balancing his duty as a prosecutor and a minister of justice against that duty of zealous advocacy. Now, his second statement was he is presumed innocent. That is a statement that the Rule 3.6 and the commentary in particular of Rule 3.6 talks about. You should say that when you're talking about that somebody has been charged with a crime. He is presumed innocent, he said. The ultimate decision will be up to the jury. Those are appropriate textbook examples of how a prosecutor should talk. He then made the following statement. We believe we will be able to overcome his presumption of innocence. We have ample evidence to demonstrate beyond a reasonable doubt that Tyler Robinson committed this murder. The defense has also criticized this statement as a statement of belief or opinion. This is not a statement of belief or opinion of guilt based on personal knowledge or experience. Instead, this is a statement tied to the evidence, which was directly relayed to rebut the mischaracterizations and the claims in the media that the state's case was falling apart, and this evidence was exonerating the defendant. This was offered in direct response to the claims that there was not adequate evidence, and the evidence that existed was exculpatory. Now, this was nothing more than the certification required by Rule 11 of the Rules of Civil Procedure. When an attorney signs a pleading, the attorney is certifying that to the best of the person's knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, the claims are warranted by the existing law and the allegations and other factual contentions have evidentiary support. So the statement that we have the evidence to prove our case is nothing more than reaffirming and confirming that certification that we made when we filed this case with the court. To do otherwise would be unethical, to file a case that we don't believe is supported by the evidence. And this is nothing more than saying we believe that we have adequate evidence to move forward in this case. There's nothing wrong with that, and there's case law that says so, and we cited that in our brief. It's a statement tied to the evidence. Now, defense counsel has said, no, that's an opinion, and compared that with the Levitt decision. And I will tell you, there's nothing further apart than Mr. Ballard's statement and Mr. Levitt's statements. Mr. Ballard says, based on the evidence, we believe we have the evidence to go forward. Mr. Levitt says, we have reviewed the evidence the jury will never hear, and we believe this witness, in that case, the eyewitness to the murder. We believe this eyewitness based on evidence the jury will never hear. So Mr. Levitt asserted his personal belief in the credibility of a witness, right? That kind of statement would be inadmissible, would be a mistrial if that statement was made in opening statement or in closing argument, right? Mr. Ballard's statement, on the other hand, is we believe we have the evidence to prove the defendant's guilt. That's an appropriate statement in an opening statement or in a closing statement. And I should say, his statement was even more mundane than that because he said, we have the evidence. He didn't say we believe or I believe. He said, we have the evidence. And that's the type of statement that attorneys are trained to say in their opening and closing arguments rather than saying anything about beliefs. Regardless, the point is the same. This is not, I believe this witness. This is, we have the evidence, right? That's an appropriate statement. It would be appropriate for an attorney to make at trial, and it's an appropriate statement to reassure the public that that attorney is proceeding on good faith, that there is the evidence that supports the charges, and that this misrepresentation and mischaracterization of the evidence does not undermine the filing in this case, the filing of this case.
Well, let me ask you a question in regards to, you use the term inculpatory and exculpatory. Isn't that to the interpretation of the fact finder?
The jury's
whether something is or is not?
Well, ultimately, yes. And I think right now that's you for the purpose of this proceeding. But yes, ultimately it is. But I don't see how any person could say that the conclusion of the report that this round came from a 30 caliber class weapon, which a 30-06, the gun found at the scene, is. I don't see how anyone could say that's exculpatory. When you say that round is consistent from coming from that gun.
Well, that's your interpretation. You're saying I can't see, but do we need to be cautious in putting ourselves in place of the fact finder or making an interpretation of what the fact finder should assume it to be?
Well, of course we need to be cautious about that, Judge, but I mean, you're the fact finder in this case. My money is you're going to say that that's inculpatory evidence. I mean, because exculpatory evidence would say this bullet could not have come from that gun. Right? That's exculpatory evidence. And that's what defense counsel claimed it was, exculpatory evidence. It's a logical impossibility for that to be exculpatory evidence. I don't think there's a reasonable way to interpret the evidence to say that's exculpatory. This bullet is consistent with coming from that gun. That's inculpatory evidence.
It's a Venn diagram with overlap.
I can't wrap my head around a rationale that would find otherwise. I don't know if defense counsel wants to make an argument afterwards, but I can't see it logically.
I'm sure they will.
I can't see it. The test was inconclusive. The bullet came from a .30 caliber class weapon. The weapon found on scene is a .30 caliber class weapon.
Okay.
Defense counsel has said, well, the state's only avenue, or the state's appropriate avenue, I think they're actually saying the state's only avenue from response to the statement, what I'm saying is a mischaracterization of the evidence in defense counsel's pleading. They say the only appropriate response is to respond in pleadings or contact defense counsel. That's all fine, but when it comes to responding in the pleadings, this was a motion to continue the preliminary hearing. The ATF report wasn't even mentioned in oral argument. When I responded to that pleading, I thought that's a non-starter. That's an issue that's ancillary to the core issue of this motion to continue, which was discovery of DNA evidence and underlying DNA data, right? So when I'm responding to their motion, I'm going to pick and choose what arguments are going to carry weight, and I believe will carry weight with Your Honor. I'm not going to address every single argument that's out there, and that's not, and beyond that, responding in the pleadings does nothing to correct this media frenzy that's happening out there that's just echoing this mischaracterization of the evidence, right? It just doesn't. My office is getting calls from the media after they read this. You know, they run the story, it gets 22 million views, all of the media says, wow, this is getting a ton of publicity, let's jump on board. They start covering this, they call our office, and as an attorney with a duty to your client, do you just say, nope, I'm going to let the media run with this and continue to mischaracterize the evidence in the case? I don't think you can do that. I think that violates your duty to your client. I think you have to be careful in what you say, of course. But responding in the pleading doesn't protect your client and doesn't protect the jury pool from unfair and undue prejudice, which is what Rule 3.6 directly addresses, 3.6c. And that's what happened here. The rule allows response to the media coverage, and filing a pleading does nothing regarding the prejudicial media coverage in this case. I will tell you, this motion has caused the state to closely review and to revise the way it interacts with the media. From the outset, defense counsel is right. We knew the rule from the outset, Rule 3.6. The day defendant was arrested, we sent letters to law enforcement agencies within the state and federal agencies as well, asking them, hey, you've got to abide by these rules, and outlining what those rules are, including the comments to Rule 3.6. We're very aware of that. We're very cognizant of that. And that's actually why we had the response we did, is because we looked at Rule 3.6. I'm assuming that's what Mr. Ballard did. He looked at Rule 3.6c and said, look, this allows me to respond. And he did. He responded as the rule allows. Your Honor, we are committed to, as we stated at the outset of this case, to abiding by the rules. We are committed to ensuring the defendant gets a fair trial. But we're also committed to ensuring that our client, the state of Utah, gets a fair trial. And when we see our client's rights being trampled and the right to fair trial being potentially undermined, we are going to fulfill our duty to zealously represent our client. If that means correcting the statement in the media, and if that's the only way to do it, I think that that's appropriate and that's allowed under the rules. I will say that we are very cautious, and we will be more cautious in the future. In summary, Your Honor, given the state of the law, given what has happened in this case, given the state of the media and the context of the statements, and given the statements that defense has alleged here, the defense has not shown enough evidence to have additional proceedings in this case. The statement is soundly and squarely within Rule 3.6c. The statement falls within what is allowed by the case law that I cited. A statement that we believe we have the evidence to move forward with the case is appropriate under Rule 11, as well as the case law that was cited in the pleading. For For that reason, Your Honor, I would ask you to deny the motion for the order to show cause. The point is well taken, and we are, as I said, have revised the way we are addressing the media, and we intend to avoid anything that could be construed as violating the court's order in the future.
All right, just a question or two. You stated earlier that if an order to show cause, and I'm summarizing, I'm not quoting you, the order to show cause was found at the sanction stage, discovery about communications may be warranted. What's your position on the request of defense for communications, internal communications, should be requested or ordered to be produced?
Yeah, that's work product, Your Honor. The conversations that we have about any strategy is work product. I think there's an at-issue exception to the work product doctrine. I think the amendment to Rule 16 actually gets rid of all exceptions to the work product doctrine if you read the language of Rule 16. But I think that if there is an exception, it would be the at-issue exception, which is are the attorney's communications, internal work product communications, at issue in the allegation of misconduct. But I do think that if there is a violation, that's the only way that those communications could be discoverable, would be after the fact, after a finding, and with regard to what sanctions should apply. Frankly, defense counsel hasn't shown any basis to believe that those are relevant and that they haven't even shown they exist, and I think that they have that burden under Rule 16. But I would also say this: those are relevant to a separate issue, right? That they're not relevant to this case under Rule 16. There is no good cause for the discovery of that material under Rule 16, because Rule 16 deals with the defense's need in this case, the state versus Tyler Robinson, not defense versus Utah County Attorney's Office. So under Rule 16, they're not allowed. There's no good cause here. There's good cause to discover the statements that are in the media, but they already have those, right? Because that's what's at issue here is defendants' rights. I don't know if that answers your question, Judge.
No, I appreciate that. And final question, same one that I asked defense. If the court were to allow an evidentiary hearing, how much time would you anticipate the state would need? Obviously, there's variables, as defense is the moving party, but how much time would you need?
Well, probably, time to cross-examine any witnesses they have. This is the unique situation defense is going to be in, as they, what are they talking about? They're going to call every attorney that represents the state in this case. They're going to call every news agency that did an interview with any state's counsel. They're going to, they could make this thing go on for weeks if they wanted to.
Well, they can't. The court manages the calendar, and so theoretically,
if allowed to, I should say.
All right, thank you.
So, I would think that it would be probably Mr. Ballard would probably be the only witness, and in that circumstance, we'd be talking 3 hours. Probably half a day would probably do. Again, I don't think the court would be, frankly, in much better position to render an opinion than it is now. What's important here are the statements that the media has reported, and defense has already mustered those. So I don't think there's a whole lot of additional discovery that would be needed, whether it's in the form of testimony or production materials.
Thank you, Mr. McBride.
All right. Defense gets another bite at the apple here.
Mr. Novak, I did state went over by 1 minute because of my question, so you have
an extra minute.
7 minutes instead of 6.
Thank you, Your Honor. I want to go back to this court's order dated September 16th of 2025, which says, lawyers who have participated, who are now participating, or who will yet participate in the investigation or litigation of this case in any way shall abide strictly by Rule 3.6 of the Utah Rules of Professional Conduct. Rule 3.6 prohibits a lawyer from making, quote, an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Close quote. This court did not give counsel leave to decide whether extrajudicial statements correcting what counsel has argued are media misinterpretations of pleadings are an appropriate exception. And so actually, what counsel's argument reminds me is that there was another option that the state had. The other option which the state had, which is probably this court's preferable option, would have been to say, Your Honor, we need to have a hearing. We need to have a hearing to find out if this court believes that when the media misinterprets the content of a pleading, we can go do media interviews and send emails correcting it. Your Honor, is that an exception to 3.6 that this court sanctions? And if the answer had been yes, then there would have been a judicially supervised crafting of that. My suspicion is the court would have said, no, 3.6 is intended to allow one party to make extrajudicial statements implicitly where another party has already done so, and we need to balance the playing field. Mr. Robinson's defense team, and I've said this before, has strictly adhered to the principle that we will have no contact with any media and we will not make any statements to any media entity of any type. And in the same way that Mr. Ballard apparently was getting this influx of media inquiries, so are we every day. And we never, ever respond at all. Because to do so would be a violation of 3.6 because there is no exception under the situation here.
So how'd make the statement
We
about
did not say in our pleading that the ATF report concluded that there was not a match. That is not what it says. And of course, our pleadings speak for themselves. The massive media interest in this case is not an escape hatch on Rule 3.6. It doesn't matter how much media attention there is. It doesn't matter whether it's accurate or inaccurate, as long as it's not something generated by one of the parties. That's just what we are all dealing with in this case. And there is nothing that we have done in connection with the media that justifies what the state did here or excuses it. I'm going to talk briefly about views of exculpatory evidence. The state, as Your Honor knows, has a burden to prove a defendant's guilt beyond a reasonable doubt. The absence of evidence that a fact finder might find probative of guilt is itself exculpatory. So in a hypothetical case, there's no fingerprint evidence. The state doesn't offer any. That's exculpatory. In a hypothetical case, there's no confession. The state can't offer it. That's exculpatory. The absence of evidence is exculpatory. So the ATF's inability to match is exculpatory. The state can say that there are parts of that analysis which are inculpatory. That's fine. But it is for the finder of fact, and it is well established that the absence of evidence pointing at guilt is by definition exculpatory. And so what this court obviously has is two different views on what evidence is of what value. And a devoted well-skilled prosecutor sees one piece of evidence one way and a diligent defense attorney sees it the other way. And the question is, what do the people in the box think about inculpatory versus exculpatory? And finally, on this discovery question, Your Honor, counsel has made references to what Mr. Ballard may have done and may have thought about and may have considered. We don't have a declaration from Mr. Ballard. We don't have any testimony from anybody in this office about what led to this play, if I may, this media play. We have argument. And that's why this court needs to investigate. And this court can't allow the state to hide behind this notion that there's no good cause for disclosure under Rule 16A4. This is a classic situation where a well-founded, not frivolous, serious allegation of a violation of this court's order in a capital case requires looking behind the curtain as to what did and did not happen. This court cannot fulfill that obligation without knowing that. And this is the case. Counsel suggested that this is not the case. This is, Mr. Robinson versus Mr. Ballard. That's not what's going on here. This is a case about Mr. Robinson's constitutional rights, his presumption of innocence, and whether the violation of 3.6 requires various types of sanctions. That is this case. It's not a different case. Thank you.
Thank you, Mr. Novak. All right. Thank you to the parties. The court is going to take this decision under advisement, and as this court typically does, we'll schedule a future hearing to render its decision, and we can discuss it at the conclusion of today's hearing. At this time, we'll go ahead and take a 10-minute recess, and then we'll turn to the other matter. Court is in recess.
All right, as they go to recess here, that whole issue, everything that was discussed there had to do with whether or not defense got the opportunity to peek into the emails inside the prosecutor's office that went around related to Mr. Ballard talking to the press, saying something to the press about the ATF reports on the ballistics. They want to see the communications that happen internally. They think that Mr. Ballard talking to the press was a violation of not a gag order, but Rule 3.6 in the Utah state courts, which relates to publicity of a trial. And it says specifically, if I can pull it up here, 3.6. Trial publicity. It says, a lawyer who's participating or who has participated in the investigation or litigation of a matter shall not make an extrajudicial statement, that's outside of court, statement that the lawyer knows or reasonably should know will be disseminated by means of public communication or will have a substantial likelihood of materially prejudicing an adjudicate proceeding in the matter. So they're basically saying, don't talk to the press. That's like a standing rule. It's not a gag order the judge has to say, don't do it. You can't make these comments that could influence the jury pool. We want a fair trial for everybody. Please don't talk to anybody. So they're saying him doing that did that. Now the state is saying we only did that because you said this. You said that the fact that the FBI couldn't say, yes, that's a match. That bullet came from that gun. Instead they said, the piece we have is too small. We can't definitively say if it is or if it isn't. We just know it's in the right class. It could have been from that gun, but we don't know if it was. It might have been from another gun, or it might have, it might not be a match, and it might. So, yeah, defense can try to spin that the way they want, but the prosecution is right when they say it is inculpatory to a degree because of the .30 caliber class that bullet came from. That matches the gun at the scene. That's inculpatory. It's not excluding. That's a Venn diagram saying here we have a circle that says this is the bullet we have, and here we have a gun that says this is the gun we have, and they overlap to some extent. That, by definition, is inculpatory. Yes, defense could say, but there's a lot of other guns it could have been, right? Look at this other part. That's the exculpatory part. Anyway, so I do think the defense may have started this. I don't think in a normal case, and by normal I mean any case other than death penalty, the judge would even seriously consider the motion by the defense. But, as they say, death is different. A death penalty case has to be scrutinized in painstaking detail to make sure you don't screw it up. It's very expensive the first time around, and it's even more expensive if you have to do it twice. And so the judge is going to play that by way of caution. We're going to sort of bend over backwards to make sure we did not do anything that the defense can come back against us and say, hey, we didn't get a fair shot at this. And so there's a likelihood that in this case we might see emails turned over from the prosecution, internal emails saying, hey, you going to talk to the press? And it's going to be like completely raw and not polished, first names, maybe even some cuss words and stuff in there. It's going to be the tea is what it would be if it's turned over. And the tea sometimes has other stuff in it too. And if it gets turned over to the defense and they find other stuff, defense will throw their hands up in the air. They will yell so you can hear them from mountain to mountain and say, Judge, can you believe this? We thought we only had a little problem. We were not expecting to uncover the terrible systemic issues that we have in this case. We need more. We need more. Now we need to broaden this. We need more. We need more witnesses brought in. We thought it was just Mr. Ballard. Apparently the entire team, bring in the interns. We need to talk to everybody. This goes so much deeper than we originally thought. It clearly, the information that's sent out now, we cannot move forward with this case the way it is right now and believe that our client has a fair trial with an impartial jury because of their actions. Judge, we're going to have to move this trial. We're going to have to move it somewhere far from here, somewhere far from where all these media outlets that were poisoned by the systemic issues at the prosecutor's office, far from them. I mean, is there a corner of the state far enough away? I'm not sure there is, Judge. And you know what? While we're at it, we probably need to exclude Mr. Ballard and everyone who ever replied on this email from the prosecution. We just can't trust now that their hands are soiled by this issue. This is what's going to happen. Okay, and I realize I'm putting the cart before the horse here, but this is the argument that literally we saw in Corey Richan's defense when they found a little error. And they pushed and pushed and pushed to get as much as they could, to get as much, mileage out of it, and asked for everything, threw everything at the wall. I think the judge is good. I think he's going to see it for what it is, and I don't think we're going to have all that the defense wants brought to pass. But they might get some of it. The judge has already ruled that the defense doesn't get to just kick cameras out because. What about the jury? He said, we're going to control it. That's why he brought the media people, the still photographer and the videographer up here and said, look, hey, this especially pre-trial media coverage of this case has a huge opportunity to impact members of the public who may be seated on the jury. And he basically, I don't think he put him under oath, but he said, Are you going to follow my decorum orders? Are you going to do everything I said so that I know that the media coverage of this event that we have right now is not going to cause problems for us down the road? And he's probably going to do that same exercise with whichever the pool media photographer is and the pool media videographer are for every hearing until court begins or maybe through it. Okay. I'm sorry. Who's... As it started, we've had the boring part. I think we've had the boring part where the lawyers argued to the judge, because the judge the decider in this one, whether or not they can do an investigation into the prosecutor's emails about talking to the media. The emails are the scoop, guys. This is stuff that normally lawyers think this is protected. This is you peering into my wallet to see how much money do you have. Okay, this is so invasive. They might get it. They might. I can definitely see a hearing with Mr. Ballard testifying, but I don't see the emails being granted until the point where the judge says, yes, we're finding there was a Rule 3.6 violation. They did overstep. They did, violate the Supreme Court rules for lawyers involved in this case. Because of that, we need to find out how bad it was, and that's where the emails would come in. So it's juicy. It's really technical, and yes, it's not designed for the public. It's just for the lawyers and the judge, and they speak in legal mumbo-jumbo, and there were a lot of those words in there. But it's a very important argument, and it's going to be a foundational argument, depending on how this goes, that could affect everything moving forward, even to when the case is held and where the case is held. So pretrial, boring, no jury, does this even matter? Just wait for the case. No, this is where the decisions are made that change the entire case. All right. Any other questions? But the defense said it was in their pleadings, which are public record. If the media took that and ran with it, and then the state responded to the press, they violated the order. They argued that successfully, I think, and that's why I say the judge. I can definitely see the judge saying, "Yes, let's bring in Mr. Ballard for 3 hours. We're going to ask him these questions." I don't think that's going to go anywhere, but I definitely see that they might be able to get that investigation, and just the fact that they got the investigation is a feather in their cap, right? They're saying, look, if anything happens down the road, Your Honor, it's happened again. We had to take 3 hours out of our day and prep. It took a whole week to prep for the last hearing, and now it's happened again, Your Honor. We need sanctions. What sort of sanctions? I don't know. Death penalty off the table? That's a sanction that the defense would love to get. And we know that courts have offered sanctions like that for violations of one type or another. So it's all strategic. And literally, the defense here, they're just hoping for life without parole, right? They're going into this with life without parole as their win. I mean, the way I see it. So. All right, it's all a game. It is, and I love it. I love it. I missed a couple comments here during the arguing here, so let me go back and get those. Wallflower member for 39 months. OG, thank you very much. ADAPS training member for 27 months on the jury. Thank you very much. Also an OG. Hi from Australia. Is this going slower? It's just me. Oh, it goes slow. The wheels of justice are not speedy at all. Shelly Small. Was there a gag order when they supposedly went on the media tour? That's why I said yes and no. Not a gag order. There's a rule that they were violating or potentially violated. That's the Supreme Court, what they call it, the SCRP Rule 3.36 or something like that. 3.6. Jennifer Cockfield, member for 24 months. OG. Thank you. Congratulations on the 2 years. And then Ivan Victor, 35 months. Ivan, my friend. Yeah, the AI jury comment coming back again. Ivan, OG. Thank you as well. All right, we have... it's a game of chess. It is. This is high-stakes chess. This is life and death chess is what it is. Mr. Robinson is fighting for his life. The state is pushing for his death. And there couldn't be higher stakes in this. And it's the fight has started already, even though we might be a while away from the trial itself. Mr. Robinson, as far as I know, is pushing for a speedy trial, which would mean the state is sort of under the gun. They have to do everything really quickly. You don't have years to analyze and have experts go back and forth and look at things. They have to get it done and get it ready now because there's a ticking clock where if they don't meet their deadline under the laws of the Constitution, Tyler goes free. If he doesn't get a speedy trial, that's his right. It's going to be a dismissal, and you need a speedy trial. You can't just stomp on that right. Speedy trial is an oxymoron in a capital case. Oftentimes, it seems that way. I think speedy trial, when the framers of the Constitution wrote it, didn't have like 90 days in mind. They were probably like a couple weeks. But that has been a flexible figure. And just whatever you do, don't look to Georgia for an example of what a speedy trial is. Because they have definitely a different take on that. Never played chess in my life, but I'd be a great lawyer, says maybe Megan, maybe not. It'd be wild if he was set free. It wouldn't happen, is what happened. It's so extreme. The state would rush to trial and drop the charges with and drop the death penalty option. They do anything they had to do to make sure that a defendant didn't just go free because they couldn't get their documents in a row. It's not. I can't remember the last time we've seen a speedy trial violation where someone just went free, like that we've watched here on this channel. Yes, it's a construct, right? Speedy trial varies. A lot of places, like in Thurston, Washington, they'll say, you've got 90 days. Speedy trial clock starts right now, 90 days. State has to do it by then or else this case is dismissed. But that number does fluctuate a little bit. And there are also allowances for things that are outside of the court's control sometimes. So it's not hard and fast, stopwatch to this many more minutes and then I'm free. All right, a couple more minutes on this break, and then we're going to pick up another topic, which I think it might go back to either hiding some of the evidence from the public or sealing some of the hearings from the media. So I'm not sure which ones are going to be argued here. There are a couple things that could have been brought up in our notice from the Utah courts to the pool media. It didn't really clarify exactly what was going to be discussed today. All right. Yes, afterwards we're going to go watch Judge Boyd. We've got a busy day today, a really busy day. Judge Boyd has a trial that we've been following for about a week now. And she's had an interesting schedule with it. It's sort of been a piece here and a piece there, as she has regular docket work as well. But it is a manslaughter trial that involves a gentleman who was driving a Tesla onto the sidewalk, struck and killed a pedestrian, fled the scene. His passenger also fled the scene, and then the passenger at one point called 911, like later, and the following day, which could have been somewhere between 24 and 48 hours later, the driver turned himself in. All right, looks like we're coming back here. Tesla,
please be seated.
Yes, and recorded
Court is
everything
now in session.
on cameras.
All right, counsel. Give me just 1 second here. All right, let's next turn to the issue of the motion in limine to close those portions of the preliminary hearing testimony which would be inadmissible at trial or which, if publicly disclosed prior to trial, may prejudice Mr. Robinson's constitutional rights to a fair trial.
That sounds like a defense motion if I've ever heard one.
Preliminary hearing exhibits which would not be admissible at trial or which, if publicly disclosed prior to trial, may prejudice Mr. Robinson's constitutional rights to a fair trial. To each side, you'll have 60 minutes to present evidence and argument. If defense would like time for rebuttal, please plan accordingly. And
so
this is defense's motion, defense will proceed first. And turning to defense.
This is keep the media out motion.
Thank you, Your Honor.
For the pretrial.
I can tell you I am definitely not taking an hour here.
All right.
Thank you, ma'am. Thank you.
Words that every judge wants to hear.
It's not the attorney 5 minutes, but it definitely won't be an hour.
All right. Thank you.
So, yes, Your Honor, the two issues before the court in this motion are the handling of the exhibits at the preliminary hearing and the motion to close the hearing itself or portions of the hearing. I'm going to work backwards because I actually think the state and the defense are mostly on the same page about the exhibits. It seems that the state does not intend to offer the exhibits in such a way that they will be viewable by the gallery. That was our primary concern with the exhibits during the hearing, and making those publishable online through the live stream or recording. That issue is not before the court at this point. I don't believe there has been a request for electronic media coverage. We do anticipate that that will happen, but that was our primary concern about the exhibits and how they are kept in the record, if they are kept in the record. I know that standard protocol is that they are withdrawn after the preliminary hearing. That's what I anticipate to happen here. However, if for some reason they need to remain in the record, we have provided a detailed table to the court of what is already categorized under the rules of judicial administration as private, protected, and safeguarded. And we're asking the court to ensure that the records are held that way if the state desires to keep them in the record for any reason. We don't believe there is any reason for that. If there is post-preliminary hearing litigation where we need to reference exhibits, we'll handle that at that time in the appropriate way, make sure they're classified according to the rules.
Okay.
So I think that actually addresses that concern. The other concern, of course, is closing the preliminary hearing, which is a little bit more nuanced and is tied in some ways to the other motion that is not fully briefed yet about the use of reliable hearsay in a preliminary hearing in a capital case. I'm going to try very hard not to delve into any of that. I know that the state still needs an opportunity to respond. Going to the two factors from Kearns, I'll address those. The first is the evidence relevant to the nature and extent of the adverse publicity that may be generated from providing evidence in an open setting in a preliminary hearing. Now, we've overwhelmed the court, I will say, with the adverse publicity in this case. We had a whole hearing about it. We submitted lengthy briefing, lengthy presentations, copies of all of the videos. So this court, I think, has a very good idea of some of the media that is being generated around this case. I also think that the argument that we just had demonstrates how sometimes the media can misconstrue the evidence in one way or another, and that can get into the jury pool. So our goal here is to prevent that from happening by avoiding publication of evidence before there has been admissibility determinations. There will be litigation about the admissibility of a lot of this evidence. There are chain of custody issues that will have to be addressed that are not appropriate for the prelim. There is 702 and Daubert issues that will be addressed as far as expert reports and testimony. And most of the preliminary hearing, as far as we can tell, is going to be based off of reliable hearsay. They're calling 5 officers to discuss a very extensive investigation, basically throughout the state of Utah. The reports are lengthy and contain lots of statements from other officers and people that collected evidence and people that talked to witnesses. And unfortunately, we're not in a very good position right now to know what of that testimony is going to be based on personal knowledge versus reliable hearsay from other officers as defined by the rule. So our solution, what we see, is closing the preliminary hearing and this court thereafter providing a transcript of what occurred during the preliminary hearing that can account for all of the evidence that wouldn't be admissible at trial. That's the solution that we're proposing here. That's the only way we see that we can protect our clients' right to a fair trial and avoid evidence getting out that potentially is going to be challenged in the future and may not ultimately be used or admissible at trial. So that also addresses the second Kearns factor. I also wanted to note, just for the court's understanding, when we talk about Kearns and we talk about Archuleta, both of these cases happened at a different time, before the use of reliable hearsay was allowed by the Utah Constitution in the way that it is now. So when we're talking about those cases and their discussions of prejudice and what open and closed looks like under those circumstances, they were very different. There were more witnesses testifying as to their facts as opposed to hearsay from other individuals. And there was more opportunity for cross-examination and the exercise of our client's right to confrontation. So now we're dealing with basically just a presentation of evidence from the state, and again, without any determination about admissibility at trial. So We are asking for that solution. We think the landscape of the evidence at this point versus those prior cases, while they are still, the guiding procedure for this court to follow, we believe the instances in this case, the circumstances of this case, the media presence in this case, and how the media has already, in some instances, taken information out of this court and misinterpreted it and facilitated misinformation about the case. We believe the only way to really prevent that is to control what's coming out of this courtroom. So that is why we're asking to close portions of the preliminary hearing if we can narrow it down. Honestly, I think that's a question only the state can answer, or the entirety of it, and we can pick through it after.
Well, so let me stop you right there.
Why don't
So
they just
looking
use
at
a grand jury?
Kearns, we have to align with the narrowly tailored. Like simply saying closing the whole hearing, I don't think that would conform with narrowly tailored. And saying let's just close the whole thing and then pick it apart afterward. Wouldn't you agree that that's a bit broad? And that's not the intent of the case law or the rules, that we get to just shut it all down and then figure out afterward.
Amen.
Or do you have a different interpretation?
Well, Your Honor, we've kind of talked about different solutions here, but the alternative is we essentially make objections as we go through the hearing, which will probably take quite a bit of time and extend the proceedings significantly. So if that's the preference, we can absolutely do that. I do think that it would interrupt the flow of the evidence and the presentation before the court to do it in that way. But if that's the preference, we're also open to that solution. But our concern, again, is that a bunch of inadmissible evidence is going to be presented without any sort of testing before it is presented and put out into the world to the jurors and biasing our clients' right to a fair trial. Does the court have any additional questions?
No.
Okay, I think the defense has a legitimate excuse or legitimate argument there. Why doesn't the state just say, let's do this through a grand jury, which is sealed, and skip the
Thank you, Your Honor. The state has tried to make it abundantly clear throughout this process that we favor open hearings so that the public can trust what happens in this courtroom. And public confidence increases when people can see justice at work. So that's our general argument. This, in many respects, is largely the media's fight, Judge, but the state is interested in weighing in on these issues here. We've talked a little about the Kearns Tribune Court, and it's clear from that decision that the public, including the media, possesses a constitutional right to access preliminary hearings. And the overall question there as far as closure is there a realistic likelihood of prejudice to a defendant's right to a fair trial? That's the overall question. And then we get into the factors that the court should consider, which are, will the evidence shown during the preliminary hearing create such negative publicity that it's impossible to hold a fair trial because an impartial jury cannot be seated at some point in the future? And the second question is important. The second factor speaks to, are there feasible and effective tools available to this court to ensure a fair trial? And we've had extensive arguments about pretrial publicity in this case. We've talked about voir dire. We've talked about extensive jury questionnaires that can be used as well. And as it applies to here, we've talked about the idea of shielding the public from some of the exhibits that are going to be offered into evidence. So let me just kind of pivot to that. We do favor, Your Honor, we favor Your Honor denying access to the public and the media from physically handling the exhibits and copying the exhibits that are admitted during the preliminary hearing. And the reason for that is expressed in the Archuleta case. And the language there is that we believe that allowing the media or the public to physically inspect or copy these exhibits may disrupt the efficient performance of justice, hamper judicial interest, or jeopardize defendant's right to a fair trial. And that is because we have not yet tried the case. Those are likely exhibits. Many of the exhibits will be used at the trial at some point in the future. And having the media access those and try the case in the public, if you will, I don't think serves the administration of justice. So I think we concur with the defense with respect to that. Now, when it comes to the closure of the proceeding, that's where we differ, I think, significantly, Judge. Because the public has a right to be present, including the media, as articulated in Archuleta, they have a right to report on all that occurs there. So there's a difference between the public being present for the hearing, observing the hearing, the media being present and reporting on the hearing, and having access to the actual exhibits. But there's real merit in the public being invited into this proceeding to watch how it plays out, to see the exhibits introduced into the evidence. They're allowed to listen to the arguments between the parties on the admissibility of it, the arguments at the close of the hearing on whether the state's met its burden to bind the defendant over for trial. And that's part of opening these proceedings, making them transparent so that the public can trust the process, what happens in this courtroom. If the court were to close the preliminary hearing, the court would necessarily be making the decision to limit electronic media coverage. So I think that Utah Code of Judicial Administration Rule 4-401.01 is in play, and the court's going to have to undertake that analysis if the court is to close this hearing or even close portions of it. And there's a number of factors that the rule asks the court to consider, some or all of these factors. And some of them clearly stand for this idea that it should be opened. The media should be allowed to cover these proceedings. For example, the adequacy of the court's facilities for electronic media coverage. Check. That one is satisfied. The public interest in and newsworthiness of the proceeding. We all know the newsworthiness of these proceedings. The potential benefits of allowing public observation of the proceeding through electronic media coverage. Again, we think that opening these proceedings creates confidence in the system. Questions of whether there is a reasonable likelihood that electronic media will jeopardize the safety or well-being of any individual. I don't think that's in play here. Whether there is a reasonable likelihood that electronic media coverage will jeopardize the interests or well-being of a minor. I don't think that's in play. Whether there is a reasonable likelihood that electronic media coverage will constitute an unwarranted invasion of personal privacy of any person. Again, I don't really think that's in play here, Judge. So I don't think that the presumption that the media can be present and report on these proceedings has been overcome under that rule. Reliable hearsay. Judge, reliable hearsay is a staple of preliminary hearings. It's important that we all recognize that this is a probable cause hearing, akin to a grand jury in many respects. Does the state have enough evidence to move this case forward to trial, forward to 702 hearings and different challenges on the evidence? And so that's why reliable hearsay is allowed.
Well, Mr. Grunander, and I know that this is a subject of the other motion, and so I want to,
sure.
Both sides will have ample time to argue that, and I don't mean to interrupt you, but just that's being reserved for a different hearing. And again, don't mean to interrupt your flow, but we're not, that's a decision for a different day.
Fair enough. I'll pivot to my main point in bringing up Rule 1102, Judge. Okay. And that is that if this court were to close the preliminary hearing, or even portions of the preliminary hearing, because of using reliable hearsay, that would essentially swallow the rule, swallow the constitutional rights that the public has to be here and to witness these proceedings. So I just think that that's an absurd result, Judge, that a procedural rule that allows for evidence to come in would negate the constitutional rights of others. So that's my primary point with respect to this motion, Judge. It's also, and I make this point in our written pleading, but the practical effects of introducing evidence at a preliminary hearing is different than that of trial. We oftentimes don't publish the exhibits like we would at trial to a jury, where it's broadcast up on a screen for the jury and the public to see. Many of the exhibits that will be introduced at this preliminary hearing through 1102 are like an autopsy report. That would not be published. Lab reports would not be published. Written 1102 statements that the court will receive will not be published. And so this idea of prejudice is mitigated for that reason alone. And then on top of that, of course, we would ask the court to essentially seal those exhibits and not allow the public and the media in the future to inspect them and make copies of them. But again, I believe the public, well, the law is that the public has a right to be present, to observe the proceedings, hear what's going on, watch the arguments, etc. And while some of the specifics of those lab reports, for example, will likely come up in argument, perhaps on maybe the admissibility of it, if objections are raised, or certainly at the end of the hearing when arguing bind over. There's a difference between being present in the courtroom and hearing those arguments and hearing references and even partial quotes of that evidence versus examining physically and copying those exhibits and having those. So again, I'm going to defer. The media is present. It's my understanding that they want to be heard on this motion. This is largely their fight, but again, the state wants to give the public the opportunity to critique these proceedings and to have confidence in what's happening in this court, and I'll submit it on that, Judge.
Well, I do have a question for you, Mr. Gernander. Being that it is the state's burden to present the evidence at the preliminary hearing, do you anticipate any of the evidence being presented that would require a closed portion of the hearing? And if so, what mechanism do you anticipate or you would advocate for to ensure that it's handled appropriately?
Judge, I don't anticipate testimony that would require closure for it to be admitted at the preliminary hearing. Again, there are going to be exhibits presented. For example, we have 2 videos. We have 5 officers that are subpoenaed to testify. With respect to 1102, we expect to rely heavily on 1102 in presenting our evidence. But these are officers who will testify to personal observations from other officers. They will also provide some foundation for exhibits that will come in. We do have one video recorded 1102 statement from Lance Twiggs. But I don't believe there's any reason to close that portion of the preliminary hearing. And, Your Honor, we have provided Your Honor with the physical copies of those exhibits, and the electronic copies are on a thumb drive, which has been provided to the court for your review as well.
Well, just to be clear, I actually had the exhibits returned because I wanted to wait till the prelim to look at the exhibits, and I haven't. And a lot of what's been proposed as potential evidence, the court has explicitly not viewed, even if it's in the public sphere, just so the court can go in with a clear mind. So I appreciate that, but I just want to put on the record, I did note that folder, and I appreciate that preparation, but the court has not, and it will not review it until the prelim to ensure that, you know, as a magistrate, I want to make sure that I go in only considering what's been properly admitted, and not to say you wouldn't properly admit it, but I just want to go in with that clear mind and only considering what has been admitted into evidence.
Okay. Should the court change its mind and wants to view it beforehand to make a determination, that information and evidence is available.
I appreciate that. Thank you.
There are 2 videos, as well, to answer Your Honor's question. There are 2 videos which depict the killing of Mr. Charlie Kirk that were taken by people that were present at the event. Those are sensitive in nature. Mm-hmm. You're watching the death of another individual, the violent killing of him. I wouldn't describe them as horrific. It's not a torture killing, as was described in the Archuleta case, but that material is sensitive. And so if that is received by the court, it would need to be published, at least to Your Honor.
Sure.
And if it's in an open court proceeding, the monitors could be turned away from the public's view so that that's not viewed, for example. But I don't believe that the hearing needs to be closed, or there's even portions of the hearing that really needs to be closed. Again, I think there's a middle ground here where the public and the media can be shielded from some of the sensitive stuff, but it doesn't need closure.
Thank you. Thank you, Mr. Gernander.
It's possible some of those videos have not been released publicly yet, even though publicly there have been a lot of videos out there.
To the media, and then we'll return to you, Ms. Visser.
Here's the media representative arguing on behalf of all media outlets.
Counsel?
And the coalition.
Thank you, Your Honor. The court has a challenging task when it comes to requests to close portions of a hearing. The court knows the distinction that's been drawn. When the court ruled on the motion to exclude cameras, it made note of the fact that we were at that time in a bit of a different world. At that point, we were not talking about a constitutional right to access. In this case, we're back in that world where we are, right? Where the public has a constitutional right to access court proceedings and court dockets. When we were talking about the question as to whether or not the public would be present for the cameras motion before, the state said something in its briefing, and it said different hearings operate different ways. And with respect to certain hearings, we're not sure where it falls on the spectrum, how strong the recognized constitutional right of access is for that hearing. Preliminary hearings are one of the small categories of hearings in Utah and nationwide that are expressly recognized as set apart. You know, it's criminal trials, and then what comes next? It's preliminary hearings. And there's a reason for that. The lead case that the court has seen and will see more of is Press Enterprise. That's a U.S. Supreme Court case, 478 U.S. 1. In that case, the court was remarking on a 41-day preliminary hearing that had taken place in California and wanted to make sure that the public had access to that, in that case, to the transcript of it. And so the reason is that preliminary hearings are often the sole occasion for public observation of the criminal justice system. In a lot of cases, that's as far as it goes. That's all the public may have the right to see. And stripped of the opportunity to participate and watch that, the public may get no insight at all. I recognize in that case something that this court has recognized, that access to a preliminary hearing and to other court proceedings enhances both the basic fairness of the criminal trial and the appearance of fairness so essential to public confidence in the system. We aren't relying on a U.S. Supreme Court case alone, as the court knows. In Kearns Tribune, this has been brought into Utah, and we were told something similar. In addition to kindling public misperception and eroding public confidence, closure of significant pretrial proceedings, like a preliminary hearing, perpetuates general ignorance and cuts off public knowledge necessary to a full understanding of the criminal justice system. It's really important that the public be allowed to access proceedings like this one. We've heard the parties reference, the defense reference at least a little bit, part 2 of a Kearns Tribune test. The idea here is that when you are seeking a departure from a recognized constitutional right of access, the party who's seeking closure, in this case the defense, needs to come forward with specific evidence about the thing that they're asking to seal and or close, and what the interest is that would justify that departure from the constitutional norm. As the court certainly recognizes, if there is going to be some sort of closure, the court has to go say in a written finding, here's why I am closing this piece off. It's why this wait and see approach, let's just get to the morning of the preliminary hearing and make this decision, won't work. How at that time would the court be able to say, I'm going to go make a written closure finding balancing these interests if you're asking me to do it on the fly? It means we need to do it now. And that's why this idea of listing every line of testimony, every bit of witness time on the stand, every potential exhibit and saying, let's seal and close all of it for 5, 6, 7, 8 different reasons, makes for a real mess, right? It makes a real challenge to say, so to be clear, you want me across 34 exhibits and 8 potential objections to make written findings that justify each one of those. I can imagine a world, and I know the court can too, when there is an exhibit, a portion of a bit of testimony, where it may be truly unique and special enough that the court would then need to hear a specific argument. But the burden to do that is on the party seeking closure because of the constitutional rights at issue here. In order to do that, the party seeking closure needs to have evidence of 2 types. One, evidence relevant to the nature and extent of adverse publicity that may be generated by the open pretrial proceeding. So I need to come show you what it is that's so problematic about it. And then, as the court recognized, specific evidence relating to the availability, feasibility, and efficacy of alternative means of selecting jurors and conducting the trial to assure the integrity and impartiality of the jury. That's from page 523 of Kearns Tribune. You need to show up with both those types of evidence. The court knows what the normal alternatives are because the court has thought through those and mentioned those in its rulings before. If there is evidence, as it should and as it can under our system, that becomes public during these pretrial proceedings, you hear a witness testify about something, you hear about a piece of evidence that's introduced. The expectation is that to the extent that that has some potential prejudicial power, you deal with that through these normal tools of jury selection, an expanded voir dire, detailed jury questionnaires, things of that sort. As we mentioned in our briefing, what you often see in Utah cases is they say by the time you get to trial, potential jurors may say, I remember hearing something about this case, but I no longer recall any details, right? And I certainly feel comfortable being able to set aside any prior knowledge that I had and focus solely what is in front of me at this case. That's the preferred narrowed means. So in order to justify a sealing, a party seeking that sealing or that closure needs to come and say why that isn't enough. Why for this specific piece of evidence, why for this specific stretch, that won't work. Again, I can imagine a world in which a showing like that is made, but we are nowhere close to that as far as granularity, as far as satisfying that burden, as far as with specificity here. I do want to mention briefly Archuleta. Both sides have talked about this different type of request, right? I want to stress that in most cases, and in this instance, what the media is asking for is essentially occupy the role that a member of the public would occupy if they were sitting in this courtroom. So if things are said out loud or presented to the court in order to justify or try to meet the burden of a preliminary hearing, the press, acting as a proxy for the public, would have the opportunity to watch, listen, consider, and report on that. The court knows that if a member of the public, as much as we appreciate them being here, said a preliminary hearing, that piece of evidence up there on the stand looks interesting to me, can I come up and hold it? The court would say, no, we're trying to preserve the integrity of this proceeding, and so you can listen to what you're seeing in the courtroom, but you can't come touch it or copy it or take it home with you, right? That's what was at issue in Archuleta. There were some pieces of physical evidence that there had been a request by the media to actually handle, inspect, copy. And in that case, the court said, well, we'll treat that differently. We think there's some different considerations at issue when you are asking to physically handle exhibits. Nothing like that is at issue here. The press has not in its briefing and does not here today seek to be able to do that type of hands-on examination of evidence or copying that was at issue in Archuleta. What the press is asking for here is what the press so often asks for, which is we are a proxy. We are here to help assist, to be the eyes of the public, to help them observe those sorts of things. So for that reason, the language in Archuleta that says there's no constitutional right to access the exhibits in that way is simply not in play. It's simply not before the court, and the court does not need to reach that question of what if somebody asked to hold or copy one of the exhibits that's being introduced at this preliminary hearing, because no such request has been made here. I know that there's been a lot of hypothesizing about what will happen with these exhibits, a lot of exhibit-specific arguments about Rule 4, 202, and various subcategories of private or protected justifications. I don't want to get in the weeds here. You could go through exhibit by exhibit, argument by argument. But what I want to stress, though, is that I think that the cleanest path and the only path that the court is really equipped to be able to take at this point is to be able to say, listen, what is presented in that hearing, absent any sort of narrow showing of closing or sealing a specific moment, should be open. The press should be able to see what a member of the public would be invited to come in and see on that day. And that would be discussion of these exhibits and being able to hear the testimony. The fact that some of this information may eventually be inadmissible does not constitute a link to showing reasonable likelihood of prejudice at trial that would deprive a defendant of a fair trial right. A party cannot simply say it's possible that at a preliminary hearing, some evidence that is eventually deemed inadmissible may be presented. As the state pointed out, that would be true in every case. That can't be used as a basis for closing or sealing a hearing in this case. The stakes here are high. Kearns Tribune says it bluntly. Democracy blooms where the public is informed and stagnates where secrecy prevails. Closing these proceedings to the public will not improve the efficacy of these proceedings. In the Press Enterprise case, they went 41 days in order to make sure the presentation was done appropriately. I know the court has no intention of using 41 days in this case, but saying it might slow things down if we had to be careful every time we close the proceedings is not a justification to close the entire proceedings. It might slow things down. It may force parties to, on occasion, say, let's talk about this specific piece of evidence. But because that's hard, doesn't justify saying, let's close the entire thing. The court has correctly not taken that path in the past, should not take that path now. Thank you for hearing us, as always, Your Honor.
Thank you. Ms. Visser.
Did he just speak from the hip with no notes?
Thank you, Your Honor. I just want to address a few things.
Wow.
First, I would propose that there could be a solution whereby we have portions that are closed, like preemptively closed, and portions that are preemptively open, if necessary. I just also want to caution the concern about admitting some of these exhibits that are protected, private, safeguarded, and the testimony that may accompany those being admitted. It sounds to me like the state doesn't intend to essentially do an end run around those classifications and have people describe those or read those out loud, and that would be our preference as well, because those are classified as private, protected, and safeguarded. So we would ask for that solution to be implemented as well.
And to that, just as you're talking about that, I'm just kind of thinking out loud. And I always encourage parties to see if there's any stipulations to exhibits. You know, for jury trials, I always encourage the parties to get together and to see. And I'm not saying you need to, but perhaps that could be something that would help resolve some of these issues. If there is that removes the need to go into detail or even to go into what could be problematic foundation laying again. But I'll leave that to the parties. The court is not intending to insert itself in those conversations.
No, that's a good suggestion, Your Honor, and we're definitely open to having those conversations in anticipation of the prelim to make things simple and move quickly, for sure.
Okay.
As far as the Rule 4-401.01, the electronic media coverage, I just want to reiterate that issue is not before the court right now. There may come a time when we need to address that when the media files their request, as they inevitably will. This court made a detailed order about how we are to address that, and so we'll address that at that time. I don't think it's a basis for this court to deny our motion for closure. It is a very different issue, right? Whether or not the media are allowed in the courtroom versus filming and live streaming is very different. So we did not go through those factors. Potentially we will in the future. So, Your Honor, we are asking for some reasonable solutions to prevent information being out in the public from the preliminary hearing that likely will not be admissible at trial. Hearsay from other officers is obviously not going to be admissible at trial. Those individuals will have to testify. 1102 statements, clearly not admissible at trial. Those individuals will have to appear. We will have the right to confront them, cross-examine them. So we're asking the court to take measures to ensure that that information is not published from the preliminary hearing. That is our primary concern with the motion to close. So we are asking for that. Thank you, Your Honor.
Thank you.
He's going to take that under advisement as well, I think, as is his
All
MO.
right.
See if there's anything else on this hearing.
All right, thank you to the parties. I appreciate the argument and briefing that was done and acknowledge your hard work and diligence. The court will take both matters under advisement and issue a ruling on WebEx. And counsel, I want to check with you. I anticipate approximately 30 minutes, as I've done in the past, in either a morning or afternoon setting on June 1st. Is there a preference of the parties? Mr. Novak.
Only that I presently have a hearing scheduled for the afternoon, late in the afternoon of June 1st, California time.
All right.
That's all.
And first, is there,
California
we've had a
That's specific.
traditional way of doing this, but do the parties have any objection for my ruling to be on WebEx to accommodate all the parties?
Media's good with that.
All right. And
The morning of June 1st would be preferred by the state.
all right. How about 10 a.m. on June 1st?
As long
for
as we can
WebEx
stream it,
hearing?
Judge, we're good.
And again, I wish to be thorough to defense. What is your election as it relates to Mr. Robinson for that hearing?
Your Honor, if he could just be present with no video, just like in the past. Thank you, Your Honor.
All right. All right.
Connect over
Let
Zoom.
me look to.
No picture.
All right, so I would like to set an in-person hearing for defense's motion to challenge the constitutionality of the Utah Rule of Evidence 1102 in Utah Constitution, Article 1, Section 12.
That's the reliable hearsay.
If granted by the court, if I rule on June 1st for an evidentiary hearing, I would also like to hold that at the same time. Again, the court is not making its mind up. It's just indicating that if the court elects to hold that hearing, it would be on that same date.
So
And
Mr.
we're
Ballard,
looking
make
at
yourself
June
available.
12th. And the availability of the parties.
Mr. Robinson might want to be there if it's the Mr. Ballard one, as opposed to just Zoom from the jail. That could be.
All right.
That could be spicy.
All right. And what I'm trying to do is address these issues prior to the preliminary hearing and allotting time to take the argument on consideration. The court intends to give serious thought and consideration to the motions and to the oral argument. So I'm trying to space it out so the court can do that and issue its ruling prior to the preliminary hearing. So for the June 12th, we'll start at 9 a.m. and we'll set aside the majority of the day. On the day of the hearing, I'll state the time constraints that we have, but as done today by counsel, I appreciate your succinct arguments. It is appreciated, and that reflects your experience and professionalism as well. With those two dates set, June 12th at 9 a.m. for the evidentiary hearing on the motion and potentially evidentiary hearing for the order to show cause, and ruling on June 1st, 2026 at 9 a.m. on WebEx for a ruling on today's proceedings, do either party wish the benefit of the record at this point?
Your Honor, I'm sorry. You said 9 a.m. on the first? I thought the court said 10 a.m. on the first. Is that right?
I did. I wrote down 9 and I said 10. So it is 10 a.m. on June 1st. Thank you for that clarification. And on June 12th at 9 a.m. All right. And as it relates to June 12th, as it relates to Mr. Robinson, what is the request of defense?
We would ask for an order to transport.
All right.
Yeah, he'll want to be there.
All right. I'll go ahead and grant that. All right. Unless there's anything further, again, thank you to the parties for being present today. And the court will be in recess until June 1st at 10 a.m.
All right. Whoa, easy on the gavel there. All right, we're going to go ahead and kill the feed for Top Mark Media. Just 1 second. 3, 2, 1, and it's done. All right. We're done as well from that feed. So we'll get everything the way we need it. Okay. All right. June 1st, we find out the answers to these 2 questions that were presented to the judge. Also, the next motion that they teased that will be argued on the 12th, the defense is arguing the constitutionality of Utah's Rule 1102, which is where they allow reliable hearsay to be used in a preliminary hearing. This is where they have 5 police officers that are going to testify to what they knew or what they talked to or what people said that they talked to. It's done in a couple different situations. Sometimes it's done in cases where the victims are quite vulnerable and it prevents them having to testify twice. Think of a child situation. And then you can just have the investigator testify the first time, and then in court the victim testifies one time. So that's one of the reasons. This is something that most states, like many states, allow reliable hearsay at this preliminary hearing stage for different purposes. Sometimes it's chain of custody or things to just speed up the process that will be addressed fully before trial or at trial. So it's in the Constitution. It's in Utah Constitution. It's allowed. It's a rule. It's a thing, and. Let me just end Top Mark really quickly. Anyway, it's going to be argued against by the defense. They're trying to change the Constitution here for their case and saying it's not fair. But that's it. I appreciate the mods. Let me just say big thank you. Amber, Red, Lois, Greeners, Josh, everybody. We are. This case does have a lot of. It's charged, right? It's politically charged, and we don't do pickles. We do pickles, not politics, and we're asking people to just save that part for somewhere else on the internet, right? If this is your hill to die on, and you've just got a lot to say on this case, and it's political in nature and whatever, we're not here for that. I apologize. There are other places you can take it. We are asking the mods. I'm asking the mods to time people out for the day if they cross that line. And because it's such a charged situation, we have to sort of be, I wouldn't say heavy-handed, but very proactive on a moderating side, because one funny little comment starts a fight with someone else as it gets bigger and bigger, and the snowball effect is real. I wish I could show you on the back end just how real that is and how problematic it is if we just allow some and then try to draw the line later on. It's terrible. It's terrible, and I wouldn't put my mods through that. So all I can say is thank you for agreeing to follow the rules. We love to watch court together. That's why we're here. Please be respectful of everybody and save yourself a day timeout. Mods, you're amazing. I appreciate all you do. And yes, there were plenty of you gave warnings. I was not going to give any warnings, but you did. LED says thank you from the mods. Thank you, mods. Thank you. We are now going to go to Judge Boyd. We have so much to do today. I want to portal. Is that okay? Can I portal? We can do it real quick if you give us just a second. Let me schedule. This is going to be, I think it's day 7 with Judge Boyd. I've got a call from New Jersey. I'm not sure who this is. Hang on 1 second. Oh, I lost it.
Call from
Paywall.
To accept, press 1. Call. from Hutchins.
I just tried to accept.
Press 1 to send a voice.
Everyone's hanging up. Now I hung up. I just hung up on everybody. AWOL, Josh, hello. I'm sorry. I hung up. Josh, you called during AWOL's call, and I tried to accept the first one. I hung up on him. We'll see just a second. Give me a second to build this, the portal over to the next court, which is going to start in 5 minutes. Okay. I don't know what Judge Boyd is going to do. We're trying to watch as much of this court as she will allow. She is sort of her own person. Here, the call's coming back in.
Call from
AWOL.
Hey, AWOL, how's it going? Sorry, I didn't mean to hang up on you there.
Hey, no, it's all good. I'll make this quick. I know you want a portal. I just want to make something clear. I know the channel rules. It'll all be Pickles, right?
Yep.
But I just want to make a quick disclaimer here where if I disagree with evidence, I am not dismissing the loss of Charlie Kirk. I just want, he was unalived, and I feel like he deserves justice. I just want the proper person or the group of people, whatever it is, to be held accountable. So if I disagree with a piece of evidence, it is not saying anything of where Charlie Kirk stood for, his position. This is all Pickles. I'm talking facts and evidence here, right?
Or your opinion on the facts.
Understand, and my opinion on the facts, correct. But I can see how it was a horrible situation. He didn't deserve that. And I can see how somebody could be tied to that, where if I question evidence, it almost sounds like I'm dismissing, what happened to him. And it's like, that's not the case, or I don't want to be taken out of context.
I'm with you, AWOL.
Right?
I feel that. I mean, yes, this is a politically charged case, and everyone is entitled to their side of their viewpoint on this. But we're going to try to watch this just from the legal perspective. Strike out the politics of everything, and let's just watch on the legal. And yes, every defendant is innocent unless proven guilty. Not until. Right? This isn't a foregone conclusion, and the evidence should be challenged. And I'm with you 100% on that. I appreciate that, and I hope we can build a place here where we can have these conversations and be able to steer clear of the pick a side and death to anyone of the other color, because that doesn't help us get anywhere. So, AWOL, thank you.
And it's not, and I don't even real quick. I don't think it's a whatever colored party thing here. It's just I was
thinking red and blue. So
that's what I meant as well. Again, I'm trying to keep a pickle, so I didn't want to name the colors, but you did. It's your channel.
It's all good.
I'm just saying, it's I feel like it's okay to say throw him under the prison for what he did. But if I go, I don't know if he did it, it goes, how dare you say that? And it's like, wait, you just convicted him before the evidence came in, and that's okay to say. But if I say I don't know if he did it, it goes, how dare you? And I think that's not fair. We can agree to disagree and have a good faith discussion. I think it should be good for the goose, good for the gander, equal on both sides, as long as it's fair and nobody's calling names. And
I'm with you 100%, and I also reserve the right to just delete any comment I choose. And the mods.
100%. Of course. I'm not telling you not to do that.
Only because sometimes, there are some legitimate conversations and discussions that are very difficult to have in a chat setting, right?
Yeah.
Where we don't get to have the context clues of voice and sarcasm and timing and question marks and our little text on the screen just doesn't do it justice. And sometimes there's a really great comment, a really great question that we just say, this isn't for here, even though it's very appropriate, it's very insightful and things like that. It's just we can't do that here. So thank you for your understanding.
Correct.
AWOL, appreciate you calling. Always good to talk to you, my friend.
All right.
Thank
you. Love the mods, love chat. Everybody be safe today.
You too. Bye-bye.
All right. Peace.
It's awesome. Appreciate AWOL. He challenges me, makes me think, and I love it. We're gonna try to go down to Judge Boyd here, and I'm just looking. It looks like she was holding a regular docket for a little bit this morning, and we're just gonna get past that part and jump right to. Is this the right one? Let's see. Buffer. Yeah, we have time to catch up. We're going to be catching up right now. Thank you, Josh. I appreciate that. I'm just looking to see if she just went on break. I'm making sure I'm watching the right one. She had a little Zoom hearing. We're getting to the end of the Zoom hearing. And the defendant is still on the stand. The defendant has taken the stand. Let's jump to this now. I think this is where we are. Tell me if this is right, Josh. Is this how it started out this morning?
Yes. All right, let's bring the jurors in.
Yeah, this is
Court is calling 2023 CR 8866 State versus Robert Castillo.
Oh, wait.
Can I have parties announced for the record.
I was going to portal. We are going to portal. It's going to be cleaner if we portal, please. Give me just 1 second. We've actually got the live portal set up. I just have to make the link and we'll jump over. That way people who are watching, just the Judge Boyd court doesn't suddenly say, why do I have to watch, Tyler Robinson for 2 hours before we get to watch the next part of Judge Boyd. Okay. This is going to be quick, so 2 minutes, maybe tops. Ready? Everybody? I'll play the music and fade it out real quick just so everyone can get the audible clue that we're done with this one and jumping over to Judge Boyd. It's a busy day. I told you it was going to be busy. Hang on for the ride. We're all set for this. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again in just mere moments with Day 7 of the Judge Boyd manslaughter trial down in San Antonio, Texas. The defense is going to be resting here shortly. We need to catch up to what happened today. We followed all the other days until now. Can't wait. So hopefully we get verdict music today. It could happen. So you guys see you in just a little bit. Bye-bye.